Hello, and welcome to another episode of Virtual Legality. I'm your host, Richard Hoeg, managing member of the Hoeg Law business law firm of Northville, Michigan. And today I think we have a very important episode for us because we're talking about the United States government and just what authority President Trump does or does not have. Now, if you're anything like my family, you may be asking yourself the question, what is an executive order? Seeing as President Trump has signed hundreds of them in the first couple of months of his presidency. What does it do? What authority does it have over me? It's not a law. It's clear from the titling of executive order that it's not that. But how does it work? What does it mean? And I think in order to have that conversation, which will be very important to our topic of discussion today, we need to understand as a first principle how the United States government is organized. Now, you might already know some of this from civics class back in grade school, but if you don't, I think this will be helpful for our understanding. So the U.S. government is divided into three branches. The first, the legislative branch, comprised of the Senate and House of Representatives, writes the laws that govern our lives, makes the rules that are enforced by the executive branch. So we have the legislative branch that writes them, the executive branch, President Trump and his administration, that enforces them. And then when he seeks to enforce those laws, the judiciary, the judicial branch, the Supreme Court at its highest level, then interprets the laws and sees whether the executive is enforcing them correctly. So we have those three branches, but because the executive branch is so big now, because the administrative state in the United States in 2025 has so many people working within it, the presidency has to decide exactly how the laws are going to be enforced and instruct the employees in that branch exactly how to do so. And the question then becomes, can Congress delegate its authority to write the laws and do other things to individuals within the executive branch that are otherwise independent from the powers of the presidency? We've seen institutions and agencies like this in Virtual Legality before. We did a lot of conversing about the Federal Trade Commission and its authority to enforce the antitrust laws against corporations seeking to merge or otherwise restrain trade. And that particular body, the FTC, has at its head a number of individuals that are appointed by the president when they are the president, but cannot be removed except for cause and have set terms that are put forth by Congress. And that is deemed an independent agency because of that authority being separated from the president. Can the president nonetheless get rid of those commissioners? Can he otherwise control that agency, which is operating under the executive branch, insofar as it's choosing who to enforce its rules against, right? And this is a part of the conversation. I just described the three branches of government, but since the founding, Congress has created a number of these agencies, the FTC, the FCC, the SEC, all these letters that sound a lot alike when you're listening to it in podcast form or watching it on YouTube. But all of these agencies that are otherwise outside the complete power of the presidency because the president can't remove the individuals if they do something that he doesn't like. So can they do that? And if they can, what are the limits on that power? And this executive order from a few days ago is perhaps the most important executive order that President Trump has so far signed because it seeks to change the way in which the United States administrative state, those agencies in the executive branch, operate. And I want to talk to you all about it because it's not as clear as you might be hearing on the internet, whether this is a good thing, whether this is a bad thing, whether this is a tyrannical or authoritarian seeking of kingly powers or monarchy or something that is otherwise required by the Constitution. We have a lot to talk about, so let's look at the executive order itself first, which is somewhat understatedly named Ensuring Accountability for All Agencies. By the authority vested in me as President by the Constitution and the laws of the United States of America, it is hereby ordered that the Constitution vests all executive power in the president and charges him with faithfully executing the laws. There is absolutely no controversy about that sentence. That is entirely true. That is what the U.S. Constitution does. The controversy, if it exists at all, is whether or not that means the president has to have the authority to remove and order the direction of everyone within the executive branch. Reasonable minds can 100% differ on this question. We're going to see how in just a minute. Continuing with this executive order, which again is just a part of the executive branch operations to instruct all of the people within his branch on how to pursue the execution and enforcement of the laws that are written by Congress, he then says the president is regularly elected by and accountable to the American people. This is one of the structural safeguards, along with the separation of powers between the executive and legislative branches, regular elections for the Congress, and an independent judiciary whose judges are appointed by the president by and with the advice and consent of the Senate, by which the framers created a government accountable to the American people. Now, all of that's extra information, right? This is an executive order. It's not a law. It doesn't have any specific way that it needs to be written. But the framing device for this is that I am not a tyrannical king seeking authority over everyone. I am not trying to become Emperor Palpatine, if you're familiar with the Star Wars franchise. Instead, what I am doing in this executive order is by design to bring us closer to the constitutional republic that the founders of the United States envision. Now, you don't have to agree with that, but that's the framing device of this particular executive order. He continues, however, previous administrations have allowed so-called independent regulatory agencies to operate with minimal presidential supervision. And this is another component of this particular discussion, which is to say the FTC obviously has been around a long time, as has the FECC and the SEC and all sorts of other letter agencies that you can think of. But just because previous presidents agreed to them, acceded to the congressional delegation and creation of these independent agencies, doesn't mean that they're constitutionally required. And this president has a different interpretation of what Congress's authority should be on this particular question. He continues, moreover, these regulatory agencies have been permitted to promulgate, that's just create when we're not in lawyer terms, significant regulations without review by the president. They make rules that are not laws. And remember, the process of making a law in the United States is that the legislature writes them, but the president has to sign them or veto them. And these agencies, like the FTC, create things like the COPPA rule that we've talked about in Virtual Legality without the need for the president to sign off on them. And so he's objecting to that practice. For the federal government to be truly accountable to the American people, officials who wield vast executive power must be supervised and controlled by the people's elected president. It shall be the policy of the executive branch to ensure presidential supervision and control of the entire executive branch. So he's objecting to the creation of these independent agencies and the creation of positions that he cannot otherwise control, direct, or fire. And so he continues from there, and we're going to skip a few of the definitions, that the Director of the Office of Management and Budget, OMB, shall provide guidance on implementation of this order to the heads of the executive departments, and that the Director of OMB shall establish performance standards and management objectives for independent agency heads. So we're going to run this government, or at least this executive branch, more like a corporation, says President Trump, as appropriate and consistent with applicable law, and report periodically to the President. The Director of OMB shall, on an ongoing basis, review independent regulatory agencies' obligations for consistency with the president's policies and priorities. So this is an area that's definitely going to be controversial insofar as the president is saying, oh, I have full authority over the executive branch. Independent agencies effectively don't exist. And so they are going to comport with my policy preferences because the people elected me to direct this branch. And these independent agencies are undoubtedly, in the near future, I would guess, going to sue over this, or Congress is. One of those two bodies is going to sue over whether the president can demand this particular directive, because it has not been the case over the course of the recent history of the United States that the presidency has otherwise accepted the existence of these independent agencies and their authority. He will also direct the OMB to adjust such agencies' apportionments, that's their money, to advance the president's policies and priorities. Such adjustments to apportionments may prohibit independent regulatory agencies from expending appropriations on particular activities. So the president is saying, I have more authority than Congress thought with respect to these agencies, and so I'm going to direct the people that are directly under my purview, like the Director of OMB, to go and check in on how these agencies are operating and change their budgets if they aren't doing what I like. This certainly sounds like a usurpation of authority, just as we're reading it right here. But there's a lot going into this that may or may not be as bad as is suggested on the internet. So hang with me for just another minute as we read the rest of this executive order and then get into the legal discussion of what this means and what it doesn't. Continuing, subject to Section B, independent regulatory agency chairman shall regularly consult with and coordinate policies and priorities with the directors of OMB, the White House Domestic Policy Council, and the White House National Economic Council. So, you FTC commissioners, you'll check in with us pretty regularly. The heads of independent regulatory agencies shall establish the position of White House liaison in their respective agencies. So not only will you check in with us regularly, you will get somebody from the White House that will work directly with you and communicate whatever it is that you're doing directly back to me so that we can adjust those budgets and we can otherwise control what it is that you're doing in the executive branch. The President and the Attorney General, subject to the President's supervision and control, shall provide authoritative interpretations of law for the executive branch. Now, this for the executive branch is super important here. I saw on my timeline and in social media and in some articles that have already been written about this, even though I don't think this executive order has been written about enough at this moment in time, suggest that this was the president usurping the judiciary, the judicial branch's authority to interpret the law. That is not the case. This is an executive order. This is an assertion that the president and his direct respondent, the attorney general, will have the authority to interpret law for the executive branch, not as it stands in a platonic ideal sense. The judiciary still gets to determine what the law is. If the executive branch brings a case against someone, they're still going to court over it. But this rubbed a lot of people the wrong way. I wanted to talk about that for a second because that is not what is happening here. The president and the attorney general's opinions on questions of law are controlling on all employees in the conduct of their official duties. No employee of the executive branch acting in their official capacity may advance an interpretation of the law as the position of the United States that contravenes the president or the attorney general's opinions on a matter of law. Now, if you're a fan of Donald Trump, then you might look at this and say, yeah, that's what the election meant. That when we elect a president to be the head of the executive branch, then that's what we were talking about, that there shouldn't be other officials that are otherwise undermining him or doing things that are opposite what his policy preferences are. That's what elections have consequences mean. But if you're not a Donald Trump fan, again, this looks like a usurpation of authority that was delegated by Congress to these other individuals, and that's going to be an open point of controversy. But that's the real executive order. I think this is probably the most important one that he has so far signed. It would upend the administrative state in the United States in a way that we haven't seen for a considerable amount of time in our recent past. But it isn't what some people are saying it is. I pulled up a sample tweet here from a Brian Allen of Allen Analysis that says, breaking, Trump just signed an executive order declaring that only he can decide what the law is. And that's in quotes because that is the famous Marbury versus Madison assertion of what the judiciary and the Supreme Court in the United States does. They interpret the law and they determine what it is. A full-blown power grab, as described by Mr. Allen here, wrapped in authoritarian cosplay. If anything, it's wrapped in populist or democratic cosplay. This isn't how the Constitution works, says Mr. Allen. The courts exist for a reason, but Trump is out here acting like a king with a Sharpie. If this stands, the rule of law doesn't just bend, it breaks. Now, this is wrong. This tweet is wrong. This message is wrong. But equally wrong is a tweet from Stephen Miller that says the founders created a unitary executive branch, meaning one individual has the power, in which the executive power shall be vested in a president of the United States, the vesting clause. All executive power is vested in the one man elected by the whole nation. No unelected bureaucrat, that would be your FTC commissioners or whatever other agency you want to think about on this score, has any independent authority. And again, going back to first principles, the legislative, executive, and judiciary branches all exist from the authority of the people, right? That's the we the people concept of the United States. The entire government has any authority over us because it's authority given to them by the people of the United States. This argument is that no unelected bureaucrat, none of these commissioners have any independent authority. It's all in the executive branch. It's all the presidents to begin with. This isn't exactly right either. And so with that as our background, I wanted to look a little bit further into this executive order and the fact sheet that the White House put out so that we can better understand what it is that they are claiming to have done here. And then we're going to look at what I think is one of the better law review articles that I have ever seen on this particular question. And if you are at all interested in law or law school or thinking that you might want to become a lawyer, you're going to want to hang in here for that because it's a really good law review article. It does argue things in the alternative, so you get to see things from multiple different ways. But if you find that to be boring or uninteresting, you're going to want to turn away from law school. Now, on this fact sheet, the president says, Article 2 of the U.S. Constitution vests all executive power in the president, much like we just saw from the Stephen Miller tweet, meaning that all executive branch officials and employees are subject to his supervision. And that's an assertion, right? It sounds logical, but it is an assertion of how the Constitution actually operates. We'll see in just a minute why it doesn't necessarily flow from the first, that the executive power is all in the president. Then it continues saying, because all executive power is vested in the president, all agencies must submit draft regulations for White House review and consult with the White House on their priorities and strategic plans. The Office of Management and Budget will adjust their apportionments, and the President and the Attorney General will interpret the law. So this is a good summary of what we just read in the executive order. I always like to go to the primary source material first, but this is a good summary. But again, it's not as hyperbolic as either of the two tweets that we just looked at, and those were just representative of some of the conversations that I have seen online. Then this fact sheet says the Federal Trade Commission, Federal Communications Commission, and Securities and Exchange Commission have exercised enormous power over the American people without presidential oversight. That is undoubtedly true. And part of what we'll see as we look at some of these cases and some of this analysis is that the Supreme Court previously allowed these independent commissions on the premise that when they were making rules, they were acting in a legislative capacity, not an executive one. And when they were essentially putting people in front of courts or tribunals or what have you, depending on the commission, they were acting in a judicial capacity and not an executive one. So the legislative can obviously delegate its legislative authorities to others as long as they're still within their power and control. And then the judiciary being implicated didn't bother anyone really. But the executive is where this really comes home to roost. And this is where these people work and live. This is how they get paid. They are part of the executive branch. And when they select who they are going to bring their claims against, that is an executive function. They are choosing how to enforce the rules and laws that otherwise they might have created themselves. So they're kind of little super governments as they stand. We've seen in the very recent past that there is some notion at the Supreme Court level currently in 2025 in the United States that perhaps some of the way these are structured is not so constitutional. This executive order is really arguing to finish the job there and say that these independent agencies are not created in a way that is in comport with the Constitution in any reasonable way. The order fulfills President Trump's promise to restore constitutional governance and accountability to the entire executive branch. Executive power without responsibility has no place in our republic. Again, I view this more as populist democratic cosplay. This is saying that I am doing this not to claim power for myself, but because the framers of our Constitution, the founders of our republic, said this is how these powers should be separated, and right this second, for the last 100 years or more, they haven't been separated in that way, and we have to make sure that the one person in this branch that was elected, outside of the vice president who has no authority over these matters, is the one to which the buck stops, right? Where the actual regulations and rules come from, so that the people, if they despise it or if they otherwise reject it, can vote him out in the next term, or that Congress can impeach him, when they don't really have that same authority or ability for any of these federal trade commissioners or SEC commissioners or anyone else. So there are reasons to look at this and say, okay, that's a good spin on it. But there are also reasons to say this does look like I'm taking power. Now, with that said, I promised you a good law review article. Let's take a look at it. This is written by Cass Sunstein and Adrian Vermeule, the former of which I am familiar with. I had the good fortune of hearing a talk from him when I was at Michigan Law. And this is about something called the Unitary Executive, the theory that the president is the one that is the sole arbiter of control of the executive power within the executive branch. As they describe it, it is a bracingly simple idea. Article 2, Section 1 of the U.S. Constitution vests the executive power in the President of the United States. Those words do not seem ambiguous. Under the Constitution, the president and no one else has executive power. The executive is therefore unitary. It follows, as the night follows the day, that Congress lacks the power to carve up the executive, to say, for example, that the Secretary of Transportation is a free agent, immune from presidential control, or that the Secretary of Commerce can maintain their job unless the president is able to establish some kind of cause for removing them. On this view, the Supreme Court's unambiguous embrace of the idea of the unitary executive in what we'll call the Myers case was a golden moment in constitutional law, a ruling on which diverse people ought to be able to agree, and indeed one that they should enthusiastically embrace. And on this view, the court's messy, confusing, neologism-based, indefensible rejection of the unitary executive in Humphrey's Executor versus the Federal Trade Commission, unless you think that case is recent, it's from 1935, upholding the independence of the Federal Trade Commission was a dark stain, one of the lowest moments in the court's history and a prime candidate for inclusion in the anti-canon of constitutional law, which is all a bunch of legal speak of saying the Supreme Court sometimes gets it wrong. And part of the job of law review articles and constitutional law professors and the rest is to look at these things and say, where did the Supreme Court go wrong? What precedents might they want to overturn in the future? And the other thing that I wanted to mention as part of the top of this article is, like I said before, this is argued in the alternative, right? Which means that, like any lawyer that you've heard talk, including this one on virtual legality, they can argue these points from multiple different perspectives in order to give you the breadth of understanding of this particular topic. So anything that they say here with the on this view proviso is advocating from an almost devil's advocacy standpoint of this is what this might look to for someone of this particular persuasion. If you believe that that's what Article 2 actually says, then this is obviously the case that Humphrey's executor that allowed the Federal Trade Commission to exist is wrong under constitutional law. The only question remaining would be, should Humphrey's executor be flatly overruled, or should it be confined as much as possible? And then we go talk about what these particular laws mean as perceived by the Supreme Court here in 2025, or more recently, I think it's 2020 for this particular case. In Celia Law versus the Consumer Financial Protection Bureau, the court invalidated the provision guaranteeing that the director of the CFPB could not be removed by the president except for cause. But the court did not overrule Humphrey's executor, it distinguished it, confining it to its facts. So you don't have to overrule a case and say that case is wrong. You can just say it was very specific to that specific case, and this case is different. You distinguish it. You say it's different for these reasons, and we're going to hold in this particular instance that those reasons are important here. The resulting opinion, however, is deeply ambiguous because it is not obvious what the legally relevant description of Humphrey's executor should now be taken to be, which sounds like a good entry point for us to go and bring up that particular court case so that we can talk about it. This court case is from 2020. You see, this is a Justice Roberts opinion. Chief Justice Roberts delivered the opinion for parts 1, 2, and 3. And we'll see if the highlighting actually took here. Under our Constitution, says Chief Justice Roberts, the executive power, all of it, is vested in a president who must take care that the laws be faithfully executed. And certainly, critics of Donald Trump have certain issues with the fact that he may or may not be faithfully executing the laws to their particular level of appreciation. Because no single person could fulfill the responsibility alone, the framers expected that the president would rely on subordinate officers for assistance. As a general matter, the Constitution gives the president the authority to remove those who assist him in carrying out his duties. Without such power, the president could not be held fully accountable for discharging his own responsibilities. The buck would stop somewhere else. So said another way, okay, the president is given the job to faithfully execute the laws. If he's got people within his branch that he can't otherwise fire, he can't control, if they go rogue, then he can't have the proper authority to faithfully execute those laws. And so he must have the ability to control for the people within his branch. The president's power to remove and thus supervise those who wield executive power on his behalf follows from the text of Article 2, was settled by the first Congress, and was confirmed in the landmark decision of Myers versus the United States, the Myers case we saw referenced in that article. Our precedents have recognized only 2 exceptions to the president's unrestricted removal power. In Humphrey's executor versus the United States, we held that Congress could create expert agencies led by a group of principal officers removable by the president only for good cause. And in United States versus Perkins and Morrison versus Olson, we held that Congress could provide tenure protections to certain inferior officers with narrowly defined duties. We are now asked to extend these precedents to a new configuration, an independent agency that wields significant executive power and is run by a single individual who cannot be removed by the president unless certain statutory criteria are met. We decline to take that step. So the court is going to hold that the CFPB is unconstitutionally created primarily because it has one director instead of 5 commissioners like the FTC or other numbers of commissioners as seen in other groups. Now, if that makes any sense to you, we'll see whether it does when we look at the court's reasoning in just a minute. That is the end of the story, right? You can't have one person, you can have multiple people, and that's the difference under constitutional law as the Supreme Court sees it. But if you look at this and say, well, that doesn't make a ton of sense as a distinguishing feature, you're really trying to overturn Humphrey's executor without saying that you were doing that, then we create this whole area of ambiguity as to what is the status of the remaining independent agencies under the executive branch as it stands after this case was decided. And that's really what President Trump and his administration is reacting to. While we need not and do not revisit our prior decisions allowing certain limitations on the president's removal power, and this is a very Robertsian decision here to say we're not going to look at any questions that might otherwise be uncomfortable. We're going to narrowly look at this as small as possible so that we don't upturn any of the administrative issues or otherwise make big changes to the U.S. government. While we need not and do not revisit those prior decisions, there are compelling reasons not to extend those precedents to the novel context of an independent agency led by a single director. Such an agency lacks a foundation in historical practice and clashes with constitutional structure by concentrating power in a unilateral actor insulated from presidential control. So we can already hear Justice Roberts saying that one person versus 5 people is going to matter a lot to me. We therefore hold that the structure of the CFPB violates the separation of powers. The agency may continue to operate, but its director, in light of our decision, must be removable by the president at will. Continuing, as a history of this particular law, after the crash in 2008, in 2010, Congress acted on the proposals to fix things and created the Consumer Financial Protection Bureau as an independent financial regulator within the Federal Reserve System. Congress tasked the CFPB with implementing and enforcing a large body of financial consumer protection laws to ensure that all consumers have access to markets for commercial financial products and services, and that markets for consumer financial products and services are fair, transparent, and competitive. Congress transferred the administration of 18 existing federal statutes to the CFPB, including the Fair Credit Reporting Act, the Fair Debt Collection Practices Act, and the Truth in Lending Act. In addition, Congress enacted a new prohibition on any unfair, deceptive, or abusive act or practice by certain participants in the consumer finance sector. And you might recognize that language from our discussions on how the FTC operates outside the consumer finance sector. It was clear that the CFPB was designed to mirror the construction of the Federal Trade Commission, but not as a commission, but with a directorship. Congress authorized the CFPB to implement the broad standard through binding regulations. Congress also vested the CFPB with potent enforcement powers. The agency has the authority to conduct investigations, issue subpoenas and civil investigative demands, initiate administrative adjudications, and prosecute civil actions in federal court. So it's an executive branch agency as we would recognize it. The CFPB's rulemaking and enforcement powers are coupled with extensive adjudicatory authority. So again, it's one of those little super governments where it has all the branches' powers within it. When the CFPB acts as an adjudicator, it has jurisdiction to grant any appropriate legal or equitable relief. Congress's design for the CFPB differed from the proposals of Professor Warren and the Obama administration in one critical respect. Rather than create a traditional independent agency headed by a multi-member board or commission, Congress elected to place the CFPB under the leadership of a single director. And again, this is very important to Chief Justice Roberts for reasons that he has not yet illuminated us on. The director serves for a term of 5 years, during which the president may remove the director from office only for inefficiency, neglect of duty, or malfeasance in office. The lower court on this particular question, took as its starting point Humphrey's executor, which had approved for-cause removal protection for the commissioners of the Federal Trade Commission. In applying that precedent, the court recognized that the CFPB wields substantially more executive power than the FTC did back in 1935, and that the CFPB's leadership by a single director presented a structural difference that some jurists, including this one, says the author, had found dispositive. But the court felt bound because we're the Supreme Court and the lower courts have to feel bound by our precedents. Continuing on. We hold that the CFPB's leadership by a single individual, removable only for inefficiency, neglect, or malfeasance, violates the separation of powers. The entire executive power belongs to the president alone. But because it would be impossible for one man to perform all the great business of the state, the Constitution assumes that lesser executive officers will assist the supreme magistrate in discharging the duties of his trust, as written in 30 writings of George Washington. These lesser officers must remain accountable to the president whose authority they wield. As Madison explained, if any power whatsoever is in its nature executive, it is the power of appointing, overseeing, and controlling those who execute the laws. That power, in turn, generally includes the ability to remove executive officials, for it is only the authority that they can remove such officials that they must fear and in the performance of their functions, obey. The president's removal power has long been confirmed by history and precedent. It was discussed extensively in Congress when the first executive departments were created. The view that prevailed, as most consonant to the text of the Constitution and to the requisite responsibility and harmony in the executive department, was that the executive power included a power to oversee executive officers through removal. The court recognized the president's prerogative to remove executive officials in Myers versus the United States. Just as the president's selection of administrative officers is essential to the execution of the laws by him, so must be his power of removing those for whom he cannot continue to be responsible. To hold otherwise, the court reasoned, would make it impossible for the president to take care that the laws be faithfully executed. And if you're reading this case so far, you say, okay, well, outside of the one person, multiple people things, Rick, I'm looking at this and the Supreme Court seems to say that the FTC and other agencies might otherwise be in trouble. And you would not be wrong. First, in Humphrey's executor, decided less than a decade after Myers, the court upheld a statute that protected the commissioners of the FTC from removal, except for inefficiency, neglect of duty, or malfeasance in office. In reaching that conclusion, the court stressed that Congress's ability to impose such removal restrictions will depend on the character of the office. And here's one of the big problems with the United States legal system and legal systems of this type in general. This is the Supreme Court saying we don't know when somebody will cross the border for making this an illegal separation of powers, unconstitutional arrangement, but we'll know it when we see it. We'll tell you later. Good luck, Congress, in writing these laws based on people that don't even exist yet, let alone people that are on this Supreme Court. Because the court limited its holding to officers of the kind here under consideration, The contours of the Humphreys executor exception depend on the characteristics of the agency before the court. Rightly or wrongly, and generally speaking, that means that this author here, Chief Justice Roberts, believes it's probably wrongly, but he's unwilling to overturn at this point in time. The court viewed the FTC as it existed in 1935, and it's unclear why that's included because is it now illegal based on what it does in 2020 or 2025? We don't know. As exercising no part of the executive power. Back in 1935, they said the way the FTC does its business is not executive in nature. Instead, it was an administrative body that performed specified duties as a legislative or judicial aid. It acted as a legislative agency in making investigations and reports to Congress, we talked about that, and as an agency of the judiciary in making recommendations to courts as a master in chancery. To the extent the FTC exercised any executive function, as distinguished from executive power in the constitutional sense, it did so only in the discharge of its quasi-legislative or quasi-judicial powers. Now, this footnote here is important because this again is Chief Justice Roberts talking in 2020. The court's conclusion that the FTC did not exercise executive power has not withstood the test of time. As we observed in Morrison versus Olson, it is hard to dispute that the powers of the FTC at the time of Humphrey's executor would, at the present time, be considered executive at least to some degree. The court identified several organizational features that helped explain its characterization of the FTC as non-executive. Composed of 5 members, no more than 3 from the same political party. The board was designed to be nonpartisan and to act with entire impartiality. In short, Humphrey's executor permitted Congress to give for-cause removal protections to a multi-member body of experts balanced along partisan lines that performed legislative and judicial functions and was said not to exercise any executive power. Consistent with that understanding, the court later applied the philosophy of Humphrey's executor to uphold for-cause removal protections for the members of the War Claims Commission, a 3-member adjudicatory body tasked with resolving claims for compensation arising from World War II. And in our current administrative state in the United States, the other commissions I don't think have been legally challenged so much based on the existence of the precedent in Humphrey's executor. While recognizing an exception for multi-member bodies with quasi-judicial or quasi-legislative functions, Humphrey's executor reaffirmed the core holding of Myers that the president has unrestrictable power to remove purely executive officers. And again, that is that Supreme Court trying to distinguish. We want both these cases to survive. I don't want to overturn Humphrey's executor because I think that would create a whole bunch of problems with all these commissions that exist in the administrative state right now. And so I'm going to say that Humphrey's executor actually said Myers was exactly right. The president has the unrestricted power to remove executive officers, but we're not talking about executive officers when we talk about the FTC, the SEC, or anybody else. The court acknowledged that between purely executive officers on the one hand and officers that closely resembled the FTC's commissioners on the other, there existed a field of doubt that the court left for future consideration. We have recognized a second exception for inferior officers in 2 cases, and just to shorten this up a little bit, this exception is for people with much less power than the FTC commissioners, much less power than the president himself. We uphold tenure protections for a naval cadet engineer and a provision granting good cause tenure protection to an independent counsel appointed to investigate and prosecute particularly alleged crimes by high-ranking government officials. That's how the independent counsel statute works. We view the ultimate question as whether removal restriction is of such a nature that it impedes the president's ability to perform his constitutional duty. Now, interestingly, that sounds like the court essentially imposing its own policy preferences on the executive branch because the president should, at least as the framers put it in the Constitution and the Federalist Papers and everything else they talked about, the executive should have the full authority to determine what would impede his ability to perform his constitutional duty. So that's already leaving a certain amount of ambiguity that the Supreme Court leaves to decide whether or not some statute affording some authority to some person is high enough in level to impede the president's ability to perform. Because the independent counsel was an inferior officer under the Appointments Clause with limited jurisdiction and tenure and lacking policymaking or significant administrative authority, it was allowed to have this tenure authority. There's another footnote about how the principal agents and inferior officers work. These 2 exceptions, one for multi-member expert agencies that do not wield substantial executive power, and one for inferior officers with limited duties and no policymaking or administrative authority, represent what up till now have been the outermost constitutional limits of permissible congressional restrictions on the president's removal power. So the court here is saying that that's really the only exceptions that we'll allow, and we will force certain of the existing laws into those exceptions if we need to. But as it stands right now, the one-person directorship of the CFPB is not going to pass muster. Unlike the New Deal FTC upheld there, the CFPB is led by a single director who cannot be described as a body of experts. I mean, he could, but that probably would require therapy. and cannot be considered nonpartisan in the same sense as a group of officials drawn from both sides of the aisle. Moreover, while the staggered terms of the FTC commissioners prevented complete turnovers in agency leadership and guaranteed that there would always be some commissioners who had accrued significant expertise, that's just not true. As we see with Chairperson Lena Khan leaving the FTC on the changeover in administration, that was her choice, and that left that expertise. People always leave when administrations change and they aren't going the direction that they would seek as commissioners. So there already is a certain amount of policy preference and control in the executive branch as it stands right now. But the Supreme Court often looks at things in the kind of platonic ideal sense, how these structures could work, rather than the reality of the situation. That's their own thing. I'm not a Supreme Court justice. I can't speak to that too much, but they do it a lot. The point is the CFPB is struck down, and it's unclear what the other commissions would do because they haven't been challenged legally, and that's the ambiguity that is talked about in this article that we are currently discussing. So, the resulting opinion is deeply ambiguous because it is not obvious what the legally relevant description of Humphrey's executor should now be taken to be. On one reading, which we will call the minimalist reading, the court's opinion might be read to say, we've made some mistakes in the past, and we may or may not overrule them. But if we can find any minimally plausible ground for distinguishing them, that is exactly what we will do. On this view, the court distinguished Humphrey's executor principally on the ground that the CFPB is headed by a single person, not a multi-member commission, along the lines of then Judge Kavanaugh's earlier opinion for a DC Circuit panel. In simpler words, go forth and sin no more. We're not going to overturn Humphrey's executor, but we're going to distinguish everything that we can. That's what the court is signaling to Congress and to these agencies in the future. But in fact, says this article, there are significant strands of the court's opinion that seem far more ambitious. Call these the maximalist reading. This reading arises because the court repeatedly describes the exception derived from Humphrey's executor as not extending to independent agencies that exercise significant executive power, as by rulemaking or enforcement in internal agency proceedings. Remember that footnote where they say, actually, the court probably described the FTC wrongly. So if the court described the FTC wrongly, and that's an appropriate way to describe the FTC right now, that it is exerting executive power of some significance, and that could apply equally to the other agencies, then didn't this court case actually just say these other agencies may well be operating outside of constitutional bounds? Then the answer to that is yes. That's the maximalist reading as described in this article. Justice Thomas, who joined the majority opinion in relevant part, also wrote a separate opinion, joined by Justice Gorsuch, saying unambiguously that Humphrey's executor was wrong and that he would overrule it. And that's one of the reasons why Supreme Court justices write dissents, is to let potential future litigants know that there are votes to overturn certain rules and precedents on the court right now. So there are at least 2 votes, probably more if you're really reading between the lines on Justice Roberts, that would be willing to overturn Humphrey's executor. And that's the state of play as it stands as of 2020, and certainly as of right now. The maximalist reading, if pursued in future cases, would affect radical changes in administrative law and indeed the fabric of modern government. The main independent agencies with multiple heads wield broad rulemaking and enforcement powers. The court's ruling thus casts a legal cloud over the removal provisions for the commissioners and heads of the FTC, the FCC, the SEC, the NRC, the NLRB, and others. For the record, that is the Federal Trade Commission, the Federal Communications Commission, the Securities and Exchange Commission, I believe that's the nuclear one, the Nuclear Regulatory Commission, the National Labor Relations Board, and others. The constitutionality of those removal provisions would seem to depend on what, particularly those agencies, are authorized to do. Whether the maximalist reading is in fact pursued depends on many contingencies, not the least of which was Donald Trump getting reelected in 2024, but it is nonetheless significant that the court read Humphrey's executor so narrowly that it might well be taken to have thrown the independence of most of the current independent agencies and longstanding understandings of that 1935 decision into grave doubt. And this, in my opinion, editorializing for a minute, is what our current Supreme Court does most poorly. This is Chief Justice Roberts' legacy, is that he writes these things so that nobody has any idea what the law is after he gets done making these decisions. And I really do think that happened here. And it does open the door, even if just a crack, for a future president like we are seeing right now in President Donald Trump to say, okay, you know what? Then all these agencies are not independent. I'm asserting my executive authority over them, and they'll have to legally challenge me if they want to stop it. And I already know, or I think I know, that there are multiple votes sitting on the court ready to overturn this precedent from 1935. Now, we have more to talk about because even as I have explained it, that is just one reading of the 2020 case, and there are multiple ways to look at this particular situation and what the unitary executive actually means. It's one I want to talk about with the most. In Celia law, the decision reflects anxiety about the powers of unaccountable bureaucrats freed from the constraining arm of the president. Is the number of agency heads, one versus many, actually relevant? The court sometimes says it's not only relevant, but crucial. Elsewhere, as we have described, the court's focus is on whether agencies wield executive power. The important thing is that on the terms of the court's own analysis, emphasizing those high-level principles, that is, which features of the history and case law are critical, it's not simply read from any previous precedent or from the original understanding of the text of the Constitution. Rather, the court arrives at its conclusions through high-level structural reasoning from what it sees as defining constitutional principles, and it expressly defends that structural reasoning as such. So this is a discussion of whether originalism, which is the notion that in order to understand the Constitution, we have to go back to the founding and figure out what they meant by the words they put in, or something else is controlling what the court might do with the unitary executive theory. In other words, the conclusion and the analysis in Celia law are rooted in large part in rich interpretations of abstract, contested principles of self-government and liberty. That is why the decision can be understood not only in originalist terms, going back to the founding, but also as a species of constitutional common law, or more precisely, as a reflection of Dworkin's notion of law as integrity, by which judges attempt both to fit existing legal materials and to justify them by making them the best that they can be. So that's more of a living document kind of interpretive set that Chief Justice Roberts really does a lot of, regardless of how you feel about him, whether you think he is conservative or not. He's not so much a pure originalist or textualist as much as he's kind of a comporting what it is that he sees into where he wants it to be at the end of the day. In what follows, we explore these two ambiguities about the opinion, which involve respectively the scope of its holding and its methodology. We also attempt to show that the emergence of the modern administrative state can be taken both to fortify and to undermine the argument for the idea of a strongly unitary executive. And this is really what I wanted to talk to you all about, which is this section on what it means to be a unitary executive, how you can look at it from an originalist perspective at the founding or in other perspectives, and what that means for understanding what it is that Donald Trump is trying to do with his executive order, why it is not the usurpation of all authority in complete violation of constitutional norms, and why it's also not nothing and mandatory as you might read the Constitution. So, with that all as long-form background, but hopefully informative and interesting background, we start with two kinds of unitariness. In a sense, everyone agrees that the Constitution creates a unitary executive. That is, there is one president, not an executive council, and the president is broadly in charge of the executive branch. But reasonable people strenuously disagree, remember, reasonable minds can differ, about what a unitary president entails. Okay, we can agree that it's one president that has control of the executive, but what does that mean? Some people believe in strongly unitary presidency. Others believe in a weakly unitary presidency. The former, strong, insists that at a minimum, the president has the constitutional authority to remove all non-inferior policymaking officials who exercise executive power, and also to control their decisions. On this view, the executive power is the president's alone, and any congressional effort to compromise that principle by limiting the president's ability to fire executive branch officials is forbidden. All those who implement the law, including all those who exercise administrative authority, must be controlled by the president, at least in the sense of being at-will employees. They have to be fireable. The court's opinion in Celia law seems to embrace this view, certainly as a matter of constitutional text and history. By contrast, those who believe in a weakly unitary presidency insist that under the necessary and proper clause, and if you aren't familiar with the way that we shorten these references to the Constitution in things like law review articles, thought we would discuss the necessary and proper clause, in which Congress is given the legislative power to make all laws which shall be necessary and proper for carrying into execution the foregoing powers and all other powers vested by the Constitution in the government of the United States or in any department or officer thereof, which is to say, the necessary and proper clause is that umbrella clause we've talked about with respect to the Federal Trade Act or other statutes that we've talked about in Virtual Legality or otherwise on this channel. It is the place where the Constitution says we've given you these powers, and also you have any other power that is necessary to affect those powers. As we see a little bit further on in this article, in McCulloch v. Maryland, this clause was interpreted to give implied powers to Congress in addition to enumerated powers. With the unanimous decision, the court held that Congress has an implied power to establish a bank, since a bank is a proper and suitable instrument to aid in Congress's enumerated power to tax and spend. Reasonable minds can differ even on McCulloch v. Maryland, an earlier case precedent that says that the Congress should be limited to only its enumerated powers. But the necessary and proper clause is used by Congress to say we have much more broad authority to do the various things that you've otherwise empowered us to do in writing the laws of the United States. So by contrast, those who believe in the weakly unitary presidency insist that under the necessary and proper clause, Congress has significant authority to limit the president's authority of removal and also supervision. They are likely to agree that with respect to some executive officers, the Secretary of Defense, the Secretary of State, the Attorney General, the president must have plenary, or total, removal authority. The president must have that authority where specific constitutional texts that make grants of power to the president, such as the Commander-in-Chief Clause, are implicated, and where tradition holds that core executive powers and prerogatives involving war, diplomacy, and foreign affairs are at issue. So this article actually skips the folks that say there isn't any kind of executive power that can be limited outside of the unitary concept, saying that at least there are some presidential appointees that Congress cannot prevent the president from firing. That's the weakly unitary theory. But they also believe that as a general matter, Congress has considerable room to structure the administrative state as it sees fit, especially where tradition suggests that agency independence is essential, as with respect to agencies that engage in financial regulation. Importantly, if we look at the fact sheet for this particular move towards accountability in government, as the Trump administration puts it, one of the areas that they are not otherwise seeking to control is, and I don't know where I put it, so bear with me for just a second here, the Federal Reserve. Oh yes, it's right here at the top. They will submit draft regulations for White House review with no carve-outs for independent agencies except for the monetary policy functions of the Federal Reserve. So this executive order was clearly written by folks familiar with the Celia Law case, familiar with what the Supreme Court had said was the interpretation of Humphrey's executor and the potential problems with overturning the entirety of the administrative state, and said, okay, we are going to try to get out in front of those things that would be the most problematic for people, and we are not going to seek to take control of the monetary policy of the Federal Reserve. So those who believe in a weakly unitary executive insist that Congress is able to immunize adjudicative officers from presidential control. They add that some administrative functions might be exercised by people who are not subject to the president's policy preferences. They believe that multiple authorities, including rulemaking and even prosecution, might be taken out of plenary presidential control, so long as doing so does not prevent the president from exercising constitutionally specified functions. And again, we have that same issue, which is to say, who's deciding when something steps on the toes of presidential functions? Generally speaking, the Supreme Court isn't going to get into whether it considers political questions or these separation of powers concepts unless they are really over the line. Congress doesn't know where the line is because of decisions like Celia Law, and we're left now with this ambiguity, especially when someone like President Trump says, nope, the line is here, I'm taking complete control over all these independent agencies. Of course, it is true that those who believe in a weakly unitary executive have to do considerable work to spell out what their position particularly entails because they are making these decisions between these various powers. Some participants in these debates speak in originalist terms, others do not. We can therefore identify 4 positions, and I really like the way they do this here. Originalist, meaning we're going to only focus on the original writing of the Constitution and what the founding thought was the way that these words were written. You could have an originalist that was in favor of strongly unitary or an originalist that was in favor of weakly unitary, or you could have either of those positions on a non-originalist backing, meaning something else, that it's just better for society or some other function that to be strongly unitary or weakly unitary. So we're going to talk about those particular cells. Seeking to uncover the original public meaning of the founding document, those in cell 1 begin with the text. Invoking history, those in cell 1 add that the contemporaneous debates show that the strongly unitary view reflects the original public meaning. Cell 1 is often thought to have compelling structural justifications as emphasized in the founding period. As Hamilton, not yet of the musical but of the founding fathers, put it in the Federalist number 70, decision, activity, secrecy, and dispatch will generally characterize the proceedings of one man in a much more eminent degree than the proceedings of any greater number. That one individual in the role of presidency will do better than a council. In addition, one of the weightiest objections to a plurality in the executive is that it tends to conceal faults and destroy responsibility. Yes, any given individual is a little bit harder to put down as the one responsible for something that the public disagrees with if it's in a group rather than a single individual in that role. A unitary executive is more clearly subject to the people and therefore well suited to a self-governing nation. If Congress were authorized to divide the executive power, for example by creating independent officials charged with implementing important aspects of federal law, all of the Constitution's structural commitments, as specified by Hamilton, would be gravely undermined. If there were any doubts, Cell 1 asserts, the decision of 1789, as it is called, resolves them. In that year, an early Congress debated the president's removal power and the unitariness of the executive at great length in the context of determining the legal relationship between early cabinet heads, Treasury, War, and Foreign Affairs, and the president. Various views were represented in that debate, but Congress ultimately concluded that by constitutional compulsion, those who execute the laws must be at-will employees of the president, at least if they work at sufficiently high levels. That conclusion, clearly emerging from the historical materials, is, on this view, authoritative with respect to the original public meaning of the Constitution. And again, this is argued in the alternative. These authors will say what cell they are in at the end of all this. They are not in cell 1, and yet they are presenting what the cell 1 view would be in its strongest possible terms. That's what a good law review article does. Those in cell 3, the weakly unitary but originalists, respond either that the text is murky and inconclusive, or that it rejects such a strong unitary view. In their view, the original understanding does not call for cell 1. With respect to the text itself, Justice Holmes put it briskly, but memorably. The arguments drawn from the executive power of the president and from his duty to appoint officers of the United States when Congress does not vest the appointment elsewhere, to take care that the laws be faithfully executed and to commission all officers of the United States, seem to me spider's webs inadequate to control the dominant facts. Justice Holmes did not spell it out, but on one view, the vesting of executive power in a president says essentially nothing about Congress's capacity to insulate certain officials from presidential control. It is a spider's web. The general idea that there is one president, and the general idea that the president has the executive power, need not be taken to resolve the specific question whether Congress can declare that some officials executing the laws are not his at-will employees, essentially that these are two different kind of concepts. If this proposition seems puzzling or provocative, those in cell 3 add that tellingly, Hamilton himself, a strong believer in a unitary executive, we just heard his writings in Federalist number 70, specifically rejected cell 1 in the Federalist and concluded that the removal power followed from the appointments clause. In his view, that meant that officials who were subject to advice and consent for their appointment could be made removable only with the consent of the Senate. In other words, the consent of the Senate would be necessary to displace as well as to appoint. Remarkably, he added this in a passage that is much less well known than it ought to be. A change of chief magistrate, president, therefore, would not occasion so violent or so general a revolution in the officers of the government as might be expected if he were the sole disposer of offices. Where a man in any station had given satisfactory evidence of his fitness for it, a new president would be restrained from attempting a change in favor of a person more agreeable to him by the apprehension that a discountenance of the Senate might frustrate the attempt and bring some degree of discredit upon himself. So, I'm not as positive that this particular writing is as suggestive of what these authors say as they are, but I will yield to their expertise on this question. I read this to mean that the advice and consent process of the Senate in bringing somebody in might well wind up in a rejection, and that would bring negativity on the president if the former owner of that role were seen to be a good person and effective in that role. But this is read to mean that the Senate would have the necessary to displace as well as to appoint as part of a secondary kind of consent to removal concept. I'm not as positive about that, but it is used in defense of this cell 3 kind of concept. Thus far, the claim is not that Hamilton necessarily had the original public meaning right. We don't need that to be correct. It is only that the textual vesting of the executive power in the president by itself need not be taken to resolve the question at hand. You can read these things in a multitude of ways. The same conclusion holds for the take care clause. That's where the president says that they will take care that the laws are faithfully executed. The duty of faithful execution need not entail the conclusion that the president can discharge law implementing officials in the president's discretion. You can see that when we talk about it, even in the Celia Law case, that we say that you need to have the ability to fire in order to control what it is that they are doing under you, because without that fear of firing, then you can't actually control the people in the branch. But that is one step removed from the actual question of whether or not you can fire people. Hamilton's views are relevant here as well. Hamilton had no problem with the take care clause, but he also believed that Congress could condition removal of cabinet officials on the advice and consent of the Senate. Consider in this regard the opinions in writing clause. The president may require the opinion in writing of the principal officer in each of the executive departments upon any subject relating to the duties of their respective offices. On one view, this clause is hard textual evidence against the strongly unitary view taken as an originalist matter. If the president is fully in control of the operations of all those who administer federal law, why would the framers and ratifiers deem it necessary to specify this particular power? And again, here, I think they probably reach a little bit too far in this argumentation. I think it is still, even if you have full control over your branch, you aren't in full control of every human being in that branch. We've already talked about the fact that the Constitution contemplates that you're going to have inferior and other officers that are going to help you as president to do what you need to do to execute the laws. So reporting is still useful, just like it's still useful in a corporation for people to have reporting requirements up to the CEO, because the CEO can't know everything, even if he's in total control of the entire C-suite level of executives. So I'm not sure this is as demonstrative as they would have it be either. And yet it is still an interesting question, right? These articles are useful in understanding better how different people can come to different conclusions on the same words on the page with respect to the Constitution. As for post-ratification history, the decision of 1789 contained a range of competing strands. It would be possible to read them as rejecting the proposition that the strongly unitary view is constitutionally mandatory, and instead as revealing a discretionary congressional choice, not compelled by the Constitution, to confer unrestricted removal authority over particular officials. After a careful study of the debates, for example, Jed Shugarman refers to the legend of the decision of 1789 and concludes that a majority of the first Congress opposed the powers cited by unitary theorists. On whether the president had exclusive removal power, the first Congress decisively answered no. So this is one of the other reasons why I am not personally an originalist, if you were ever wondering, and that is to say I think that you can generally comport originalist doctrine into whatever position you want to have, and that the Supreme Court right now, as an originalist court, tends to do that, tends to decide what it is that they want to decide for whatever interpretive reasons they have, and then say we can shoehorn in certain historical evidence into what it is that we've already decided. I view this exercise as emblematic of that, and it's why I'm not an originalist. If you were to describe me, I'm probably a textualist on these scores, although I'm never going to be challenged on that because I'm not going to have the Supreme Court justice on my resume. If so, the decision of 1789 might have no bearing on congressional efforts to immunize from presidential control the decisions of agencies with other sorts of authorities. In addition, prominent legal historians have read both theory and practice during the founding era as an endorsement of the weakly unitary view, at least in some form. Now, there are also non-originalist approaches, right? We don't have to go back to the founding. We can instead just look at the structure of the government from a kind of naked or first principles kind of approach. For various reasons, many people are not originalists. They do not believe that the original public understanding is binding. They too commit to following the text, of course, but they have other primary reasons to interpret it in a different way. In the context at hand, the rise of the modern administrative state, arguably an unanticipated development, might be taken to motivate non-originalist approaches to separation of powers questions. Said another way, the founders, as bright as they were and as smart as they were in what they did to build the United States up and how the government operates, could not have anticipated the multitude of agencies that are existing under the executive branch, how Congress would delegate authority to those agencies, how they would be formed. And so without that anticipation, we have to start analyzing things somewhat separately from the way they are strictly written in the U.S. Constitution. Cell 2 can be seen as an exercise in constitutional common law and translation. The basic idea is that in a period in which the executive branch is wielding unanticipatedly expansive power that touches so many domains of domestic affairs, the founding commitments to accountability, dispatch, coordination, and energy call for strong unitariness, even if those commitments authorized weak unitariness 2 centuries earlier. It is one thing to say that in, for example, 1800, Congress had the constitutional authority to immunize certain agencies and institutions, not so fundamental to national life, from plenary presidential control. It is quite another to say that Congress can carve out an assortment of crucial agencies affecting the economy in multiple ways, such as the Federal Communications Commission, the Federal Trade Commission, the Nuclear Regulatory Commission, and the CFPB, and let them do their work without control from the constitutionally specified executor of the laws. In the modern era, fidelity to constitutional commitments calls for insistence on presidential primacy, even if it did not quite do that in the founding era, when the administrative state was so much smaller and less central to people's lives. And I do think that that's at least a compelling argument to say, all right, they didn't anticipate it. And right now, if we do believe in Federalist 70, that the usefulness of a president is that he can respond to things better, faster, and more ably than a council or Congress can, then it's better to have the president have that authority over these various agencies and to have, as described in the executive order of Donald Trump, the people determining whether or not they like the direction a president is going in. It is true that this approach to constitutional interpretation might seem looser and more speculative than originalism, supposing, quite controversially, that the latter yields straightforward answers. And that's a little bit of glibness, that's a little bit of snark. It's lawyer snark in a law review article saying, okay, originalism, Some people say that that's just a direct line to God, as it were, that you can just read the text, look at the historical documents, and have the answers. And that's quite controversial because, as I already suggested as part of this video, in general, I think there's a lot of historical records that can be pushed and prodded into whatever it is that you want to say from a legal theory kind of perspective. But even supposing that the latter yield straightforward answers, there's still reasons to not go for an originalist approach. The ironic conclusion embraced by those in Cell 2 is that even if the founding generation did not believe that a strongly unitary presidency was necessary to promote their own deepest commitments, such a presidency is necessary now, given the sheer size and nature of the contemporary administrative state. Those in Cell 2 think that those in Cell 1 do not have the original understanding right, but for reasons of principle, they are happy to make common cause with them. A firm rejoinder comes from Cell 4, and spoiler alert, this is where the authors actually live. They believe in a weakly unitary theory, not supported by originalism at all. Perhaps Cell 2 gets it exactly wrong. If fidelity is the goal, perhaps we should emphasize the risks of concentrated power and the importance of checks and balances, and the need to allow Congress to have some flexibility given the diversity of circumstances that give rise to new agencies. This is essentially saying Congress is the best place to have this particular responsibility live rather than the presidency. Perhaps the real concern, highlighted by changed circumstances, is the capacity of just one person, acting on their own, to move the government in their preferred direction. It should not be necessary to mention that this capacity is anathema to the founding commitments. It raises the specter of monarchy, right? As I suggested in the thumbnail, it's kings and constitutions that we're talking about here. Is this a usurpation of authority? When you give it to one person, when you say independent agencies can't exist, that does start to look like a collection of powers. The strong unitary presidency or imperial presidency does start to look a bit like a king. As James Landis put it in a famous translation-based defense of expert administrative tribunals, the administrative process is, in essence, our generation's answer to the inadequacy of the judicial and the legislative processes. If the doctrine of the separation of power implies division, it also implies balance, and balance calls for equality. The creation of administrative power may be the means for the preservation of that balance, so that paradoxically enough, though it may seem in theoretic violation of the doctrine of the separations of power, it may in matter of fact be the means for the preservation of the content of the doctrine, the spirit of the law, rather than the words of the law, if you will. If we accept sweeping delegations of lawmaking power to the president, then to capture accurately the framers' principles that deserve our continuing adherence, we must accept some, though not all, congressional efforts at regulating presidential lawmaking. And I think that though not all is actually very important here. We'll talk about where I think this winds up at the end of this video, but I think that what is most likely is we get a Supreme Court that will see some challenges and decide that this executive order is okay for some of the commissions, some of the agencies, but not all of the agencies. And that's very likely where Roberts Court winds up on almost every decision. You would not go broke just betting that Chief Justice Roberts will find a way to split the baby in a way that probably makes things more ambiguous for the next decade. But that's where I think this likely winds up. Given the risk of a discretion-wielding, immensely powerful set of administrative authorities concentrated in a single person, Congress should have the authority to insulate at least some authorities from presidential control simply in order to preserve diffusion of power. The strongest example may well be the Federal Reserve Board. If presidents could control it, they could promote their own short-term political interests by reducing interest rates to the detriment of the economy's long-term health. Heaven forfend. Certainly no president has ever put pressure on the Federal Reserve Board to hurt the economy in interest of the president being reelected. A similar argument might apply to the Federal Communications Commission, whose independence might be deemed necessary to prevent a situation in which the president is punishing their political enemies and rewarding their political friends. Now, the counter-argument to all of this is that, okay, that's fine. These agencies should not be under the president's purview because the president could manipulate them in this way, but that Congress has the authority to pull them back, to say, all right, we're not going to delegate our own lawmaking, our own rulemaking authority to these agencies under the president's power, and we're going to keep that power on our own, and that's a more kind of platonic ideal of what the founders envisioned when they put forth the Constitution. You won't see that in this article, but I do think that that is an existing counter-argument. These arguments could easily be generalized, for example, to the FTC, which has the authority to approve or disapprove mergers, and to a range of financial authorities whose decisions might bear on the short-term political prospects of the president. There are some things that should be outside the executive's purview. I do not disagree with that concept at all, but I think maybe Congress should keep that power for itself, and to the extent that it tries to delegate it to others, that this might be a functional way to penalize that delegation, is to say they'll all operate under the presidency, and so you should be really careful about delegating that power. Our goal here is not to resolve these questions, says the authors. At the same time, we agree that on originalist grounds, some executive officers, including the Secretary of State, the Secretary of Defense, the Secretary of the Treasury, and the Attorney General, must be at-will employees of the president. They are enforcing the president's will on things that the Constitution directly gives the president authority over. but we are not originalists, and we would give substantial weight both to judicial precedents and institutional practices over time, which means that we land in cell 4, which can easily fit, broadly speaking, with judicial decisions since 1926. Said another way, they are conservative, not in the Republican sense of the word, but in small c land, to say we don't want to have a judiciary make decisions that would otherwise upturn the entire history of the last 100 years of American jurisprudence or the administrative state. And so we're going to find ourselves in cell 4 because we don't want to see that happen. Thus far, our more modest goal has been to offer a concrete sense of why many people believe that a strongly unitary executive is constitutionally mandatory and why many people reject that proposition. So going back to the purpose of this video, when we see things that say the rule of law doesn't bend, it breaks, or that he obviously has authority because no unelected bureaucrat has any independent authority, both of those positions are undoubtedly wrong. They're the hyperbolic ends of the curve of understanding of this particular question. And if you're here in Virtual Legality listening to me, then you know that we can do better than that, right? We can have a better conversation about these things. You might look at an executive order like the one that President Trump put forth on February 18th, 2025, and be scared about it. Be scared about what it means. That is totally within your rights, but it does not mean that it is just a usurpation of authority. It does not mean that he is trying to declare himself king. It is not the end-all and be-all of that conversation, although I will add to that particular point that it might be nice if someone told him. Certainly, President Donald Trump does himself no favors when he goes out with tweets like saying, "Long live the king," with respect to some aspect or another of what he is doing, and I understand people's reactions to that. Yet, the way he actually is operating right now is well within the bounds of his authority. Executive orders directing his attorney general to do things is well within his authority, and we can expect that one or more of the agencies, or maybe even Congress itself, will bring some kind of litigation on this particular question about whether he has the capacity to require these agencies to report to him, to adjust the apportionments of these agencies in that regard. And we also know that his Department of Justice has already put forth challenges to this particular question. As we see in the letter from February 12th, just a few days before that executive order, it said to Senator Durbin of the Committee on the Judiciary that I am writing to advise you that the Department of Justice has determined that certain for-cause removal provisions that apply to members of multi-member regulatory commissions are unconstitutional, and that the department will no longer defend their constitutionality. Goes back to the Myers case that we talked about. It basically says we would ask the court to overturn Humphrey's executor. And this is, again, kind of normal procedure for a president seeking to change something within the law. To say, all right, Supreme Court, you've indicated that this is bad precedent. Why don't you go and make this decision? You need a case or controversy to make these decisions, and so we're going to give you a case or controversy. Nevertheless, the Senate Judiciary Democrats put forth a very political statement that says Pam Bondi weaponized the Justice Department, is no longer defending duly enacted laws to protect consumers and workers. She's with wealthy special interests, not the American people. We can expect online that politicians from either stripe are going to defend their guy or attack their guy in ways that look like this. But as you now know, having listened or watched this video in its entirety, that is not the entire state of affairs, and it's important to get that right when we're having conversations of this level of importance. This is a very important executive order. This really does have the possibility of changing our understanding of the American presidency now and into the future, which is one aspect of things that people always forget, right? If Joe Biden were to return for a second term after Donald Trump concludes his term, then he would have this authority over those agencies as well. These are all things that move forward into the future. So this is something that is not unique to Donald Trump. He isn't declaring himself king. It isn't a usurpation of authority, or at least not a naked one as ascribed to him by various places on the internet, but nor is it something that is clear and obvious just by the text in the Constitution itself. Now, with that all said, if you found this informative or educational, please consider supporting us on Patreon or through memberships and super chats on our live streams on this channel. I very much appreciate the support. I can't do this without listeners and viewers like you, so I very much appreciate that. But if you don't have the money or you don't want to give that financial support, there's absolutely no obligation to do so. Please just consider subscribing, leaving upvotes or downvotes, commenting on these things, telling your friends that we're having these conversations, and leaving questions or comments below this video, because I like to respond to those. I like to have these conversations. If you can't tell, I'm passionate about this stuff. I really think this is important for people to understand, and that the current discourse online is not sufficient for people to understand it, and honestly results in passions inflamed, results in misunderstandings, and people not really knowing what's going on with the U.S. government. I wouldn't handle things the same way as the Trump administration is doing, but be that as it may, since they are the actual acting presidential administration right now, I would see people have a better understanding of what is happening and what is not. So this has been Virtual Legality for today. Thank you so much for joining me, and I will see you on the next one on the Hoeg Law YouTube channel. Virtual Legality is a YouTube video series with audio podcast versions presented as commentary and for education and entertainment purposes only. It does not constitute legal advice and does not create an attorney-client relationship. If you have legal questions about the topics discussed, please consult your own legal counsel.